I can't think of anyone better to dig into all of these questions than Neil Katyal. He is a former acting U.S. Solicitor General and an MSNBC legal analyst. I have so many questions, but I want to start just kind of with the timeline of this, because I know you've said there's no reason for a delay, but there's also every reason to think that Trump's legal team will want to delay the process. I mentioned some of them, but what tactics are you going to be watching for that you expect they might try to deploy?
So first of all, Jen, I think that Donald Trump had a really terrible week, not just because of this May 20th scheduling in the stolen documents case, but also receiving that target letter from Jack Smith that you mentioned a moment ago about the January 6th and the days leading up to January 6th potential crimes that Donald Trump committed. So I think the bottom line in the news this week is that it's very likely that Donald Trump is going to be facing 2 more additional indictments from Jack Smith and from Georgia before, say, Barbenheimer leaves the theaters. It's really that severe for him. And with respect to the, to the timing here, you're absolutely right. May 20th, if it holds, is an appropriate date. It's a date well before the election. It's a date that can accommodate the campaign schedule and the like. But Trump is going to try and take every single thing on an appeal. He's going to say, for example, there's the use of classified information, and that procedure violates his constitutional rights. He's going to say there's attorney-client evidence that's being introduced into this criminal trial, and that violates his rights and the like. The good thing about our system, though, is it's written so that defendants can't slow down and take what we call interlocutory or immediate appeals to the Court of Appeals or to the U.S. Supreme Court. You got to wait till the end of the trial. So Trump can try, but I think right now, May 20th is a trial date that could and very well should hold.
That's incredibly helpful, and I was waiting for the Barbenheimer reference we haven't had yet in the show today. I wanted to ask you, we've all also been in this terrible week for Trump on kind of another version of indictment watch because of that target letter that was sent, but we also learned about a number of high-level witnesses who Jack Smith and his team still want to talk to. What does that all tell you about the timing of a potential indictment? Should we all be kind of pressing refresh, or could it be longer than this week?
I think we should be pressing refresh. I think it's likely that something will happen this week. So Jack Smith sent this target letter to Donald Trump saying that we're looking at you specifically for the violation of 3 criminal statutes. He doesn't have to do that under the Justice Department rules, but it's very common. And it doesn't mean that he's guaranteeing that there will be an indictment. Sometimes target letters are sent and there's no indictment that's ultimately brought. Here, however, I think that all indications are this is heading to an indictment. You don't send a target letter to a former president unless you're pretty darn sure that you've got the goods. And it does look like that Jack Smith has the goods. There's reports of the fact that Governor Kemp from Georgia has been called before Jack Smith to provide evidence about the fake electors plot. There's suggestions that Mark Meadows, Donald Trump's former chief of staff, may have provided evidence against him to the Jack Smith investigation. And there's, of course, what we all know. We saw for 2 months what Donald Trump did after the November election and all of the different things. And the January 6th committee has uncovered a lot, leading a very respected federal judge, Judge David Carter in California, a federal judge, to say it's more likely than not that Donald Trump committed a series of federal felonies, including 2 of which were named in the Jack Smith target letter.
So in that target letter, it kind of outlined 2 of the charges that many of us expected: conspiracy to defraud the United States and obstructing an official proceeding. What was more surprising to us non-lawyers was a Reconstruction-era statute on the deprivation of rights. What was your reaction to seeing that in the target letter?
Gratitude. I said from the beginning that that statute, 18 U.S.C. 241, which was enacted to prevent the Ku Klux Klan from depriving newly freed African Americans of the right to vote and other things, that was an appropriate statute to use. It really does describe what Donald Trump did, which is that he conspired with others to deprive people of their civil rights. In particular, what he was doing with his henchmen was saying to the state legislatures, hey, there's vote fraud here. You can throw out the vote in your state and just send your own hand-picked slate of electors to Washington, D.C. to count in the Electoral College and deprive all of the citizens in a state like Arizona or Georgia of their votes. That is a preposterous legal theory. Indeed, I just argued a version of it in the United States Supreme Court in a case called Moore versus Harper and won it 6-3. I mean, it is so anti-democratic, so corrosive, and 18 U.S.C. 241 is exactly the right way to think about going after it.
Neal Katyal, thank you, as always, for providing tons of clarity for all of this legal stuff we're all following. I really appreciate it.